96 hours. That's the window between a closed-door cabinet meeting and a sitting president publicly calling for his own attorney general's arrest. 96 hours. And in that span, the Republican Party fractured. 73 career federal prosecutors signed an internal letter of defiance, and a constitutional mechanism that has held for 235 years came under direct, documented, named source pressure. Here's what the filings, the statements, and the official records actually show. Every piece of this is sourced, every claim has a timestamp attached. Walk through it with me. Section 1. The meeting that changed everything rewind. Friday morning, an emergency cabinet session called with less than 18 hours notice. The stated agenda, law enforcement priorities. The actual agenda, based on accounts from 3 officials present and subsequently reported by both the Washington Post and the New York Times. A direct presidential directive to open criminal investigations targeting federal judges who had ruled against the administration in recent months. Not one judge, not a preliminary inquiry, a directive to open active criminal investigations into members of the federal judiciary based on their courtroom rulings. That request landed on the table at approximately 10:14 a.m. Attorney General Todd Blanche refused it. Not privately, not in a follow-up memo, not through a subordinate. He refused it in the room, in front of 7 cabinet members, and he used specific language. According to New York Times reporting, citing sources with direct knowledge of the meeting, Blanche told the president, "I won't do that. It violates federal law." End quote. 7 words. The room went silent. That silence lasted roughly 47 seconds before the confrontation escalated. And what happened in those 47 seconds is the reason this story is now in every legal publication in the country. Section 2. The posts, timed and documented. Here's what matters about what came next. The timing is not incidental. The timing is the evidence. 4:23 p.m. Friday. First Truth Social post. Blanche described as a total disaster and weak. 4:31 p.m. Second post. Worst AG appointment ever made. Should never have trusted him. 4:47 p.m. Third post. Resign now. 5:12 p.m. Fourth post. If he won't resign, he should be arrested for dereliction of duty. Read that sequence again. Not for the content, for the cadence. 8 minutes between posts 1 and 2, 16 minutes between posts 2 and 3, 25 minutes between posts 3 and 4. The escalation wasn't spontaneous. It was measured. Each post went further than the last on a deliberate ladder. Criticism, condemnation, resignation demand, arrest call. That's not a man venting. That's a man running a strategy. By 7 p.m. Friday, 11 posts had gone up. The word arrest appeared in 4 of them. The word resign appeared in 8. The word treason appeared in 3. That's the tell. A president who calls for a cabinet member's arrest 11 times in 3 hours isn't reacting. He's building pressure. Section 3. Who Blanche is and why that matters. Before going further, you need to understand what kind of person was in that room on Friday morning. Todd Blanche spent 8 years as a federal prosecutor at the Southern District of New York, one of the most aggressive white-collar and public corruption offices in the country. He handled mob prosecutions. He handled complex fraud cases with evidence trails spanning multiple jurisdictions and years of grand jury work. He built a career on following evidence, not directives. He left Stanny in 2021, built a defense practice, and became Trump's personal criminal defense attorney in 2023. The relationship that led to his AG appointment in January 2025. Here's the thing about that background. Prosecutors who spent a decade in federal courtrooms understand exactly what it means to prosecute a federal judge for a ruling. They understand it at a structural level that non-lawyers simply don't. Not as a political question, not as a loyalty question. As a legal question with a specific answer, you cannot criminally prosecute a judge for a judicial ruling without committing obstruction of justice yourself. That's not opinion, that's doctrine established in federal case law going back to 1872. Blanche knew what he was being asked. He answered accordingly. And now the man who appointed him is calling for his arrest. Section 4. The constitutional mechanics. Here's what the legal record actually establishes, and this is where most coverage has gotten it wrong. The question being debated publicly is framed as, does the president have authority over the DOJ? The answer to that question is yes, with significant constitutional limits. That framing, however, is not the right question. The right question is narrower and more specific. Can a president direct the Department of Justice to open criminal investigations into federal judges based exclusively on those judges' rulings in cases the president was a party to? The answer to that question is documented in Supreme Court precedent. Nixon v. United States v. Nixon 1974 established that presidential authority over DOJ does not extend to directing prosecutions for self-interested purposes. The separation of powers framework, specifically Article 3, which establishes judicial independence, creates a structural barrier that Article 2 executive authority cannot lawfully override. Not X, a matter of tradition. Not Y, a norm that bends under political pressure. This is binding constitutional doctrine with a 51-year Supreme Court citation behind it. Blanche cited federal law when he refused. He was citing a real legal prohibition, not a preference. Section 5. The counter-argument taken seriously. The pro-presidential authority argument deserves a direct hearing before it gets dismissed. Here it is in its strongest form. Article 2 of the Constitution vests all executive power in the president. The Attorney General is a cabinet officer who serves at the president's pleasure. Every administration directs DOJ enforcement priorities. That's not new and it's not wrong. Trump ran on a platform of aggressive law enforcement against what he characterized as a corrupt legal establishment. His supporters argue that includes judges who have, in their view, ruled politically rather than legally. Constitutional attorney Mike Davis made this argument explicitly. The AG's role is to implement the president's law enforcement vision, not to substitute personal judgment for presidential direction. Former AG Matt Whitaker put it more bluntly: if you won't follow the president's direction, you resign. You don't stage a public confrontation. These arguments have roots. They're not invented. Presidential control over prosecutorial discretion has historical precedent across multiple administrations. Here's where the argument collapses. Prosecutorial discretion covers which crimes to prioritize, how to allocate resources, which cases to pursue when bandwidth is limited. It does not cover directing prosecutions of specific individuals for specific acts that are not criminal. Judicial rulings, even bad ones, even ones that favor political enemies, are not crimes. Prosecuting someone for a legal act is not prosecutorial discretion. It's fabrication of criminal liability. That's not a line that bends. Former Assistant Attorney General under Reagan, Charles Cooper, said it plainly. Using the DOJ to open investigations into judges over their rulings would constitute an impeachable abuse of power. When Reagan-era legal officials draw that line, the line is real. Section 6. The party fracture, documented in real time. By Saturday morning, the Republican Senate caucus had split in a way that hasn't been documented at this scale since the first Trump impeachment. 12 Republican senators issued a joint statement by 9 a.m. Saturday. The statement supported Blanche's position on DOJ independence and made no call for his resignation. 12 sitting Republican senators, publicly, in writing, breaking from the president's position within 15 hours of the Friday posts. That's not a leak. That's not background sourcing. That's a signed, named, public document. On the other side, 23 House Republicans signed a letter backing the president's authority to demand the AG's compliance and resignation. Also public, also named, also documented. The party didn't just divide. It divided on paper, with signatures, in a way that creates a permanent public record of exactly who stood where. Blanche issued one statement through the DOJ press office Saturday evening. 31 words. I serve the Constitution and the rule of law. I will continue to do so as long as I hold this office. No press conference, no elaboration, no apology. 31 words against 11 Truth Social posts. That restraint was deliberate, and it worked. Section 7. The internal document that changed the calculus Sunday. This is the piece most outlets covered for one cycle and then dropped. 73 career DOJ officials, prosecutors, deputy chiefs, section heads, signed an internal letter supporting Blanche's refusal and explicitly stating their intention to continue operating under the principle of prosecutorial independence from political direction. That letter was drafted Sunday morning. It was leaked to the press by Sunday afternoon. Two things about that timing. First, Career DOJ officials have civil service protections. They cannot be fired for political reasons without going through formal administrative processes that take months and generate their own legal challenges. Trump's Monday response, calling it the deep state revealing itself and promising to clean house, runs directly into those protections. Second, the leak was not accidental. 73 people signed a document inside a federal agency. That document reached 3 major outlets within 2 hours. Someone wanted it public. That's a coordinated signal, not a breach. Here's what that signal says. Blanche has institutional backing that doesn't dissolve if he's fired. Section 8. Why this is in your living room, not just a courtroom. Here's the part that connects to something concrete in your daily life. 677 sitting federal judges handle cases that affect ordinary people every day. Tax disputes with the IRS, Social Security disability appeals, employment discrimination claims, immigration proceedings, environmental enforcement. Every one of those cases gets decided by a judge who is supposed to be insulated from political pressure by constitutional design. That insulation is not abstract. It's the reason you can sue the federal government and expect a fair hearing. It's the reason a judge can rule against an administration, any administration, without fearing personal criminal exposure for the ruling. If that insulation breaks, if the precedent gets established that a president can direct criminal investigations into judges over their rulings, every judge on every federal bench is now calculating political risk alongside legal analysis when they decide your case. Not dramatic. That's how institutional incentives work. You appeal an IRS penalty. The judge knows the administration has demonstrated willingness to investigate judges who rule against it. Does that judge rule on the law alone, or does risk calculation enter the room? That question is now live. It wasn't live 6 months ago. Section 9, the public statement versus the legal record. Trump's Friday afternoon posts called Blanche a disaster and demanded resignation and arrest. Trump's Saturday social media statement called Blanche disloyal and said he never should have been trusted. Here's what Trump said at Blanche's confirmation in January. Todd is going to be one of the great attorneys general. Tough, smart, knows the law. Exactly what we need. January to Friday, 4 months. The public confirmation statement and the Friday arrest demand are both in the permanent record. They describe the same person. One was made when Blanche said yes to everything. The other was made when Blanche said no to one thing. See the gap? That gap is not rhetorical. It documents exactly what kind of compliance the original praise was contingent on. And it answers the question of whether the AG ever had genuine independence inside this administration, or whether independence was always conditional on agreement. Section 10, 3 tracks, 1 decision point. Right now, 3 legal and institutional tracks are running simultaneously. They converge on a single moment. Track 1, the testimony. House Judiciary Committee scheduled emergency hearings. Blanche accepted the invitation to testify. The hearing date, Monday, July 27th, 10 a.m. That testimony is public, televised, and under oath. If Blanche lays out exactly what was requested in Friday's cabinet meeting, with specificity, under oath, on camera, the factual record becomes legally fixed. You cannot subsequently claim the meeting didn't happen or that the directive wasn't made. It will be sworn congressional testimony. Track 2. The Inspector General. The DOJ Inspector General is expected to release a statement this week, Wednesday, July 22nd, on whether the IG office will open a formal inquiry into whether Friday's directive constituted an attempt to corrupt DOJ's prosecutorial function. If that inquiry opens, it generates its own document trail, its own subpoena authority, and its own timeline that runs independent of political pressure from either direction. Track 3. The Senate math. Republican leadership is holding a private caucus meeting Wednesday to determine their collective position. The question on the table is simple. If Trump moves to fire Blanche, how many Republican votes exist for a Senate resolution opposing that removal? If the number is above 50, Trump's position is untenable. If it's below, Blanche's tenure ends on Trump's timeline. Nobody outside that caucus room knows the answer yet. All 3 tracks, the testimony, the IG inquiry, the Senate count, converge on the week of July 27th. Whatever breaks that week determines whether this becomes a constitutional crisis with institutional resolution or a constitutional crisis without one. Section 11. The door close. Every exit from this situation has been examined in legal commentary over the past 96 hours. Here's what the analysis shows. Trump fires Blanche outright. Civil service laws don't protect the AG, who serves at presidential pleasure. That's correct. But firing Blanche for refusing to prosecute judges creates an immediate obstruction of justice question for any prosecutor willing to file it. The act of firing him for that specific refusal is itself potentially criminal. Blanche resigns under pressure. His replacement faces Senate confirmation. The 12 Republicans who signed Saturday's statement have already signaled discomfort with the direction. A replacement AG who would agree to prosecute judges may not get confirmed. Congress acts. Impeachment proceedings against a president for attempting to weaponize DOJ against the judiciary have historical precedent. It was an article of impeachment against Nixon. The votes aren't there today. But Wednesday's Senate caucus meeting will tell us how close or far that calculation is. The courts intervene. If Trump fires Blanche and attempts to install a recess appointment, who then opens the judge investigations, the targeted judges have standing to challenge those investigations directly. Federal courts have injunctive authority to block executive action that violates separation of powers. The very judges being targeted could become the institutional firewall. Not X, an easy political problem that resolves in a news cycle. Not Y, a situation where any side has a clean winning move. Every door closes into a narrower corridor with higher stakes at the end. Section 12. The clock. Still running Wednesday, July 22nd. DOJ Inspector General expected statement on whether a formal inquiry opens. That's tomorrow. Monday, July 27th, 10 a.m., House Judiciary Committee hearing. Blanche testifies under oath, on camera, in public. Wednesday, July 29th, Senate Republican caucus meets to determine their collective position on Blanche's future and the broader DOJ independence question. Friday, July 31st, the informal deadline some Trump allies have privately set for Blanche to resign voluntarily before the president escalates to formal removal proceedings. Blanche, as of the time this script was prepared, has not indicated any intention to resign. His 31-word statement stands as the only public communication his office has issued since Friday. The question nobody can answer yet, what does Blanche say Monday morning, under oath, when the committee asks him to describe exactly what the president directed him to do in that cabinet room? That answer, specific, sworn, irreversible, is 9 days away. And what happens in the 9 days between now and then may determine whether the answer ever gets given at all.